And Sarah, Delegate Godide is asked to go first. I think that she has a chair to chair a subcommittee. Yeah.
Chair, whenever you're ready, I can take the roll.
All right. Good morning, members of the Subcommittee of Social Services. This meeting will come to order, and I will ask the clerk to open the roll for attendance.
Madam Chair.
Okay.
Delegate
Delaney is chairing another subcommittee, so she's probably going to join us when he can. But we have quorum. There are 5 people present. Thank you, Madam Clerk.
You're welcome.
All right, so we are going to get it started because we have 2 hours and we're trying to finish all of our business today. So the first bill that we are going to listen is going to be 1962. Delegate Godides, are you with us?
I am here, Madam Chair. Thank you very much.
Thank you, Delegate Godides. The floor is yours.
Thank you, Madam Chair. Madam Chair, I bring you HB 2275. It comes to us from the Virginia Poverty Law Center. Oops,
hold on 1 second. Yes. Yep.
I'm in too many committees at the moment. All right, let's try this again. HB 1962.
Correct.
Coming to us from the Virginia Poverty Law Center. And this will ensure that more of Virginia's children who come to the attention of the child welfare system can be raised by relatives when parents cannot keep or regain custody. Placing a child in their own extended family reduces the trauma of removal from a child's home. Virginia is the 2nd worst state in the country for children aging out of foster care without a permanent connection to any family. And focusing on this kin first will help Virginia do better by children. Research shows that family connections are vital to ensure healthy child development, and they do best when raised by their birth family. But if they can't be with their parents, placement with relatives or someone they know and love is the next best thing. Federal law recognizes this with preferences and requirements that relatives be found and considered for placement. And Virginia law recognizes this, strengthening policies to find relatives and fictive kin. Fictive kin is someone who has a relationship with a child, even if it's not a blood relationship. Federal and Virginia law provides exceptions to terminating a parent's rights when a relative can take legal custody of a child, providing a child with the opportunity to find permanency within their extended family while maintaining the ability to inherit from the parent and maintain a connection with them, even if they are unable to ever regain custody. The Virginia Department of Social Services recognizes the importance of family for children and is promoting a kin-first culture among local departments. So this bill will further strengthen policies in favor of kin care for children in foster care, Madam Chair. And we have Valerie LaHoureux from the Virginia Poverty Law Center here to speak and answer questions that, if the questions go beyond me, which they well might.
Thank you, Delegate Godides. Does any members of the committee have questions for Delegate Godides? Okay, being none, can we, do we have any people in support or opposition of the bill, Madam Clerk? If you
Yes, Madam Chair. We have 2 members to speak for the bill and 1 member to speak against the bill. Would you like me to go down the list?
Yes, please.
Our first speaker is Allison Gilbreth. Allison, if you could please enter the room.
Good morning. Good morning, Madam Chair, members of the committee. Allison Gilbreth with Voices for Virginia's Children. First, we want to thank Delegate Godides and Valerie from Virginia Poverty Law Center for working together to bring this bill forward. As an organization, we have been extremely supportive of making Virginia a kin-first state. We want to ensure that as many children as possible reach permanency before they turn 18. And we know that relative care is one of the best ways to do that. So we ask for the subcommittee to pass this legislation on to the full committee. Thank you.
Madam Chair, our next speaker is Valerie Laheru. Valerie?
Thank you, Madam Chair and members of the committee. Valerie LaRue from Virginia Poverty Law Center. And I work with Delegate Delegates on this bill because I hear a lot from families around the Commonwealth about difficulties that they have when they're trying to gain custody of children who are in foster care and their family members or relatives or neighbors or friends of the family, or sometimes even teachers who want to take in children who are in foster care. And sometimes there are barriers to that. I also hear sometimes from local departments that they find that sometimes the court is a barrier to them. So that was why I work with Delegate Goditis on this issue. We've heard from the Department of Social Services and also from the court about some concerns that they had with the language. And so the substitute that I think the committee has before it addresses some of those concerns. I understand there may be some remaining concerns. I think those are things that might be able to be dealt with by some line edits. Specifically, there's, I think, a line at 371 where there's language struck out at line 371, 372. And I actually agree with the court that that should be unstruck. But other than that, I think that this will help families, make it easier for children to go to families and stay with people who love them rather than being stuck in foster care. Virginia does have a very bad record, both of finding foster families who are relatives and making sure that children can go to relatives when they're going in foster care, and also in aging out of foster care without a permanent family. And that is so harmful to children. Children who age out of foster care really struggle for the rest of their lives. So we really need to do more to help children find families to be a part of, to be a permanent part of. And this is an effort to help that. Thank you.
Thank you. Do we have a substitute?
Madam Chair.
Madam Chair, I'm sorry, I forgot to offer a substitute.
Yes, I'll make it available online right now.
All right, can we have a motion to adopt the substitute?
So moved.
Second.
Thank you. The motion has been presented by Delegate Aboli and seconded by Delegate Aird. Is the substitute? Could you tell us the differences between the original bill and the substitute, Delegate Goditis, really quick before we let the new speaker come in?
I'm going to leave that to Ms. LaRue, if that's possible, Madam Chair.
Yes, absolutely. Yes, go right ahead. If we can have her back to explain us the differences.
Yes, and it might be best to hear from Ms. Stanton, but what we attempted to do with this, with working with the substitute, was to make sure that the bill would not jeopardize any federal funding. So for instance, federal law doesn't allow there to be enumerated exceptions to when a petition would be filed for termination of parental rights, but it does allow for there to be examples of when a petition would be filed for exceptions. So examples versus enumerated exceptions would not jeopardize Virginia's federal funding for foster care, which is, of course, very important because federal funding pays for a very large portion of our foster care budget. The other things that we did was to reduce some of the burden on the courts to make some kinds of findings at various stages, and also put some of the language, made sure some of the language was consistent with other areas of the code so that there weren't things that were inconsistent that would make it hard for the courts to carry out their work, or for local departments to carry out their work. Thank you.
Thank you. Do we have more speakers, Madam Clerk?
Yes, Madam Chair, we have one speaker speaking against the bill, and it's Eric Reynolds. Eric?
Good morning, Madam Chair, members of the subcommittee. I'm Eric Reynolds from the Court Improvement Program at the Office of the Executive Secretary at the Supreme Court of Virginia. The court opposes this bill and the substitute for a number of reasons. And while the substitute has addressed some of our concerns, there are some significant overarching concerns that remain, and we continue to oppose the bill. One thing to try to understand is that the statutory scheme for these foster care cases and the court processes for these cases, it's very complex. Each statute, each provision is interrelated with others. So amending one will most definitely affect the implementation of others. And we think great care and thought must go into making these amendments in order to assure the cohesiveness and interoperability of all these statutes and to effectuate the policy goal that underlies this bill. Now, this bill introduces a number of inconsistencies that can result in a lack of clarity, increased litigation, and confusion causing disparate interpretations, lack of uniformity in application, and that can, of course, negatively impact the cases, affecting the implementation of the statutes by the judges, the attorneys, the parties, and ultimately the permanency of the children in foster care. For example, the bill adds fictive kin to the provisions that address dispositional options that are before the courts in these foster care cases. I can see that sprinkled throughout the substitute in lines 152, 154, and so on. The language that is being introduced here, the additional adding fictive kin, can cause confusion because it is inconsistent with some of the foster care goals that are permissible under the statute that uses specific language. And so we need to make sure that the language is consistent, again, in order to allow the statutes to work together with each other and to effectuate the policy goals underlying this bill. And now this particular amendment dealing with fictive kin and adding fictive kin to the same level with relatives in these dispositional options represents a significant expansion of foster care policy, a huge policy shift, in our opinion, that really, if we're going to effectuate this, we really need to do this in a more thoughtful and comprehensive way to assure that consistent wording and language remains throughout the statutes, not just these statutes that the bill amends, but some of the other statutes that also affect foster care cases. Again, due to the complexity and interoperability of these statutes, rather than in a piecemeal way of just adding fictive kin here and there to try to change that policy. Again, our goal here is to prevent confusion, prevent misinterpretation, but still try to effectuate the interoperability and functionality of these statutes. There are some other concerns that we have that are kind of smaller in nature, but still quite important. Language that's not necessary as it's duplicative, doesn't belong in the statute that the bill adds to, specifically lines 365 and lines 577 of the bill. Again, interfering with the whole interoperability of these statutes. Language that's being struck that should not be struck, that need to remain in the statutes. Those are found in lines 371 and 380 of the substitute. And also significantly, the bill includes amendments that are not in line with relevant federal law that could potentially jeopardize federal funding in some instances, specifically the addition of language on line 612 of the substitute. There are a lot of details that would take a while to go through, but I'm glad to respond to any questions you or the committee members may have. Thank you.
Thank you. Do we have any questions for the speaker?
Chair?
Yes, Delegate Air.
Thank you so much. I just wanted to ask a clarifying question. So relative to these inconsistencies throughout the statute that you have described, would you categorize those as technical cleanups that need to occur in order to make the language merely consistent? Or are these substantive to the goal that I think Delegate Goditis is trying to accomplish that? And I guess the short version of this question is this cleanup that could occur if, let's say, our attorney, Ms. Stantz, and Delegate Goditis were to work through and just make sure those things were corrected, or is it far greater than that? Because you did state a lot, but I'm trying to determine if those are technical in nature or really substantive to what she's trying to accomplish.
Madam Chair, Delegate Aird, to address your question, I think there are some things that are technical in nature can be fixed rather simply and quickly. However, the overarching concept that I introduced my spiel on about the whole inconsistencies with adding fictive kin is more comprehensive, and I'm afraid I don't think we have enough time in this session, in the short session that we have here, to be able to comprehensively look at those inconsistencies and make sure that we're using the right language in the right statutes, because we use the terms relative, fictive kin, and there's also language that talks about persons with legitimate interest sprinkled throughout these statutes, and they're being used for particular purposes within these statutes. And if we mix and match or mix them too much, it's going to cause confusion. And so it would take a more comprehensive look than just a technical fix here and there.
Thank you. Follow-up question, Madam Chair?
Delegate Air.
Thank you so much. In your experience, have we attempted to clean up is not the right word. Do you know the history of whether or not we've attempted to incorporate fictive relationships in this statute in the past? I'm just trying to figure out, have we been kicking this issue down the road, or has there been incremental progress? Just trying to think that through, if you know by chance.
I think there's been some incremental changes here and there. Again, my point is this policy change is going to require something more comprehensive than piecemeal like we have been doing. Now, fictive kin was added last year as a permissible foster care goal in a statute in Title 63.2, but that was in relation to the eligibility for the Kinship Guardianship Assistance Program. Now, that language is there, again, in that statute, which drives what courts can do in context of foster care cases and what foster care goals they can approve. What this bill today is trying to address are some other dispositional options that are open to the court by adding fictive kin to the same level as relatives. Again, in the context of foster care cases, we have these various terminology that's being used, and we don't want to confuse who is who and who falls under what category. Is this a foster care goal, or is this a custody transfer in connection with something else, a custody petition filed by fictive kin or relative?
Thank you.
Madam Chair, if it would be all right with you,
Delegate Goditis, yes.
Thank you, Madam Chair. I think that we have two witnesses that can speak to those points. Again, LaRue and M. Parente are both here, and they have comments on Mr. Reynolds' comments, if that would be all right.
Yeah, that's fine. Can we bring them in, Madam Clerk?
Madam Chair,
Madam Chair, this is Valerie LaRue, and I think M. Parente probably is in a better position to answer some of those questions. So I'd defer to her.
if you could please enter the room and mute your microphone.
Madam Chair, members of the committee, my name is M. Parente. I'm an assistant director with the Division of Family Services with the Virginia Department of Social Services. We have no position on the bill. We've looked at the language. Our concern was primarily about the exceptions to the termination of parental rights language that was in the original bill. We believe the substitute addressed that issue, which would have been a problem in terms of the federal funding. In regards to what Mr. Reynolds is saying, we So our local departments do work with relatives and fictive kin. We feel like it's important for kids who enter foster care to be placed with people who know them. Our guidance to the local departments and some of the changes that have been made in code are in that direction of increasing that kind of practice at the local level. I cannot speak to all the sections of code. What we looked at is consistent with our practice. It's consistent with the guidance that we give the local departments, but I really can't speak to what Mr. Reynolds is talking about in terms of what conflict that might cause for judges in terms of other sections of code.
All right, thank you.
Madam Chair,
Delegate Bowley.
question for Mr. Reynolds.
Yes, go ahead, Delegate Bowley.
Mr. Reynolds, a very simple question for you. Obviously, there's a great need in foster care. We all agree with that. I hear horror stories of kids gone without homes and loving people to take care of them. I see a bureaucracy here that is explicit. How are we going to correct this so we can move on and not have to deal with it for another year or two?
Madam Chair, Delegate Avoli, as I mentioned before, in order to effectuate some of these policy changes and incorporating the fictive kin into these foster care cases and allowing local departments to be able to, and courts to consider the involvement of fictive kin in foster children's lives as proposed. Again, we've got to do it the right way with the correct language to make sure that all the statutes speak the same language, that so that there's no room for misinterpretation from Judge so-and-so in this county from what Judge so-and-so in this other county is interpreting. Again, it's not about the policy underlying this bill. It is about how we go about making these changes so that the courts have the proper tools to be able to make the dispositions that are being suggested here, to be able to involve fictive kin as they do relatives. It's not just a matter of adding this word or this phrase into the existing statutes. It's going to require a more comprehensive look at how these statutes interrelate, particularly the 16.1, the Title 16.1 statutes dealing with the court process.
Follow up, Madam Chair.
Delegate Bowley.
How do we get from point A to point B? How long is it going to take? I'm an impatient person, especially when we have needs like this.
Madam Chair, Delegate Avoli, I can't speak to how long it would take. I can say that the court has made a lot of efforts to try to encourage relatives and fictive kin in foster care cases. We have provided a lot of tools to judges and attorneys involved in these cases to forward the policy underlying this bill. But with regard to the specific changes that are being requested in this bill, it really would depend on getting these stakeholders together and involving the courts in the discussion about how to draft this in the first place, to be able to make sure that the language remains consistent so that the courts can implement these changes effectively. I can't give you a time. I'm sorry. I don't know how long it would take, but it would take the stakeholders getting together and hashing out these issues line by line.
We see a good bill here that has complications of legality, is what you're telling me.
Yes, they're legal in nature. Again, it's not toward the policy itself.
Okay, thank you. Thank you, Madam Chair.
Thank you, Delegate Bowley. Delegate Tran.
Thank you so much, Madam Chair. I think
more of a question, I think, but both for the witness who we've heard, I think, expound on his thoughts on the complications of this issue, but I'd really like to hear from counsel. I think I'm a little bit confused if on the underlying policy there's agreement, and then it's how do you make sure that the statute reflects that? Why is that not a review of that section where you then identify where it's most appropriate to make these changes? I'd like to hear on that piece, and then why it sounds like it needs a much more complicated overview with stakeholders where, if we make the changes in the statute, it would then drive any additional guidance to the courts. Thank you. Madam Chair. Delegate.
Yes, Council, go ahead.
To be honest, I'm not sure. I think we would need to do a more comprehensive, if that is a legitimate concern and something we need to look into, we can do that. It's something we need to go through. It would take a bit of time. I'm not entirely certain exactly what sections would be in conflict or where the issues would lie. So it is possible to identify what those might be and come up with language to draft them. It would take a little bit of time. It's not something I think we can do in a subcommittee meeting. It's just a process. So what was the other piece of the question?
I think that might have answered my question. Thank you. Thank you, Delegate Air.
Thank you, Madam Chair. I think this might be a question for both the patron and maybe Sarah. I'm just going to state it and see how it shapes out. I have a bit of discomfort supporting legislation where I hear from the Office of the Executive Secretary that there are significant legal ramifications. But I also recognize that we are trying to balance the difference of technical changes that need to occur throughout the statute. And I think I'm trying to understand whether or not it's relative to that section as a whole, relative to both policy and the technical language. I have seen other bills go through a process where we work on them in the interim with the stakeholders, or they go through, or they get assigned to a commission to work on through the interim. I guess I'd like to hear from the patron whether she's amenable to something like that. And then trying to clarify with maybe Sarah, is this the case where the entire section needs to be assessed and evaluated for a possible rewrite? Or how do we position ourselves in a way where we're not continuing to kick this down the road, but we do set it on a path forward so that we can come back and address it? And then ultimately, if the patron is okay with that, given the number of issues that currently exist with the language as prepared. So I guess that was two questions, sorry.
Thank you, so
Madam Chair.
Yes, Delegate Godidy.
Can I tackle that, Madam Chair?
Sure, go ahead.
Madam Chair, I have had the good fortune in this last year and over the last 15 years of knowing many cases where this kind of care by someone who is not a blood relative or a relative by law is raising children. I know a woman who was handed a newborn baby, no relationship to the family at all, but just told by the mother, who happened to be an addict, who said, "I know you're a good woman, will you please raise this child?" I know of a 15-year-old boy who, when he came out as being gay to his parents, the stress was so great that I don't really know, was he asked to leave or did he decide to leave? Goes to a friend's house and his friend's parents raise him. I mean, this stuff is happening all the time. It's time to start to codify this so that families can have the rights and these children can have the rights. And these children, I don't know where to start where I would love to have something accomplished in this session. I think it's really important. I also want to say that I didn't hear that there was this strong an objection to the bill until 3 minutes before the committee started. It is my understanding that the people that I had been primarily working with had been talking to the people with the other viewpoint and never heard an objection this strong. So I hope we can go forward and start to make some progress with this kind of kin first foster care, Madam Chair.
Thank you, Delegate Goditis. Do we have any additional questions to the patron or any of the speakers?
Madam Chair,
Yes, Delegate Air.
I feel like I'm talking too much here. I think I'm maybe speaking to the bill.
Go ahead, Delegate Air.
Madam Chair, I want to thank Delegate Goditis for bringing this language forward. And I wanted to take this opportunity to clarify that in no way, shape, or form do I think the questions asked, or at least my comments, are any indication of not supporting the underlying policy measure. I'm very familiar with the concept in which she expressed. In fact, in a number of minority communities, I'm very familiar with this occurring, and not even in as formal of an arrangement. The need to have relatives take care and concern for individuals that do not have that, I'm deeply familiar with, and I know how critical of importance it is. But having said that, I also recognize the fact that the words we put in these code sections have meanings and they have consequences. I don't want to kick this can down the road, but I also don't want to be back here in this committee next year trying to rectify language that we adopted that has had unintended consequences. I know how frustrating it is to not hear that someone has opposition to your bill as a courtesy in advance, so that you have the opportunity to rectify those things. And so the only thing that I guess I would offer, Madam Chair, is either we pass this bill by for the day in an attempt to try and work through these barriers that exist in the bill right now, although I've heard that it would take a lot more than that, or we need to find a way to perhaps write a letter to an entity to work on this in the interim. But that is really the only options that I see before us.
Thank you, Delegate Air. Does the patron is amenable to either or?
Whatever gets it done, Madam Chair. I am at the mercy of the subcommittee.
Thank you, Delegate Goditis. So we have a motion of the floor where we are going to either pass by the bill or continue it with a letter to 2022. Is that accurate, Delegate Eric?
Parliamentary inquiry, Madam Chair.
Yes.
I assume the motion has to be either or.
Yeah. So would I just, exactly. So do I have any other members of that committee that wanted to participate in that conversation so we go into one direction?
I guess, can I ask a clarifying question of Sarah? Sarah, do you believe that if we pass this bill by for the day, we can attempt to address some of the technical or conflicting or interchangeable use of these words in the statute? I thought I heard that might not be possible, but I wanted to clarify once more.
We can try. I'm not totally sure what the scope of the problem is, to be honest, at this time, which makes it harder to answer that question. And I'm happy to do everything I can to move this ahead if you would like to do that.
Okay, so
I'm not clear on the scope of the issue.
What I will say is I'll make a motion, or I move that we pass the bill by for the day, and adding additional context outside of the motion that if we find ourselves back here unable to have accomplished all the concerns raised, then we will take alternative action. But at this time, I move to pass the bill by.
Second.
Right there. Okay, do we have?
Madam Chair?
Yes, Delegate Tran.
Are you aware if our subcommittee will be meeting one additional time before crossover, Madam Chair?
That's where I wanted to address. This bill will have to be reported and referred to appropriations. And we got an email yesterday where is the willing of this subcommittee? There's a deadline of January 28th or 29th. Is that correct, Council?
Yes, Madam Chair, our plan is to have our last HWI meeting tomorrow, and certainly that's the last meeting that we have that we can move bills to appropriations. We are, I believe, going to have to meet tomorrow night in Block 5 to wrap up some of our work. So that would be our last meeting. Before.
Okay. Delegate Delegate Aird, I see you both unmute.
Madam Chair, I have a alternate motion to discuss before I make it. So an idea.
Okay, so we have a substitute motion by Delegate Tran. So Delegate Tran, could you state your motion?
I think Delegate Aird was talking, but I can't hear.
Yeah, let me withdraw my motion since the motion is actively on the floor. All
right. Okay, that motion that Delegate Aird presented has been withdrawn. Delegate Tran.
And to the patron, Delegate Goditis, I fully support the change that you were trying to effect. And with heavy heart would make a motion to see if we could, and I don't know how to put this properly before us, but request that the proper entities take a look at our code and identify all the places that need to be changed and harmonized in order to move this policy forward so that in this coming session next year, Delegate Goditis can bring back an omnibus bill that achieves this across the board, both her goal and putting to rest any concerns that some of our stakeholders might have.
Thank you, Delegate Tran. So to consult, this will be a motion to continue the bill to 2022 with a letter, Council? Or how do we present this motion?
A parliamentary inquiry, Delegate Guzman, I'm not sure that
Yes.
we continue bills in an odd year such as this.
So what will be the proper motion, the Delegate Council?
Delegate Chair, you are correct. We generally can't carry over bills in a short year. It's not a proper motion. I think what you could do in this case is we can take the bill by for the day. If there is a simple fix to this problem that we can figure out what the problem is and how to fix it tonight, it could be pulled up for either a subcommittee tomorrow or something else to move it forward so that we could move it through tomorrow. And if not, we could pass the table the bill or take the bill by for it again with a letter at that time.
Would you, I'm sorry, Madam Chair, I had an idea.
Yes, Delegate Tran.
If it's not easy to fix between now and the next time we are able to hear it and make sure that we pass through full committee for appropes, would you be able to have a substitute Chapter 1 bill that directs the right in state agencies to study this issue and get us the proper changes that holistically need to be made to achieve this goal?
All right, I see an app from, let's go ahead, Delegate Aird, so we can consult.
Clarifying question for Sarah. When a certain
Yes.
section is ordered to be rewritten, does that come by way of like a Section 1 bill, or how does that process work?
Yes, Madam Chair. First of all, there is something we could do to direct a study. I don't know that we can necessarily turn this into a Section 1 bill. It would depend on the scope of what we're asking them to do. You can't turn a bill into a study midway through, but there are things we could look at doing. Should this bill, if this bill ends up tomorrow in a posture where it can't move forward, but we want to solve some problems. So there are things we could do. If the final outcome is that we cannot figure out how to solve whatever these problems are tonight, you could, one good option is a letter from the chair, or the committee can actually set up a process to review the situation and draft language in the interim. There are a couple different options we could explore. And some of that will depend on what we identify, what the nature of the issue really is, and what it is we need to do to solve it. So we can work on this afternoon to have something worked out.
Yes, Delegate Eric.
I think the appropriate motion is to take the bill by for today and allow you all to explore all these things.
Okay, so that we have a motion from Delegate Eric to pass by the bill for the day, seconded by Delegate Tran, and I think we will address this in full committee, if I understand correctly, Sarah. Yeah. All right. So, Clerk, we're going to pass by. Is that a voice vote? All those in favor would say aye.
Aye.
Okay. Against it? All right. Delegate Goditis, we will see you in full committee. Thank you.
Madam Chair and members of the subcommittee.
Thank you. All right, so it's 11:44, so we're gonna have to move really fast because we have like 5 more bills. So let's bring Delegate Samira. Is that next on the docket?
Madam Chair, we have Delegate Levine's bill at the top. Do you want to start there and then go down, or do you want to go to Delegate Samira and then go back up to the top?
Yes, if we can go back to the top, because I understand that there are a lot of speakers lined up for Delegate Levine. So
Okay.
we'll just take care of these bills that do not have that many speakers, so we can just go ahead and take care of that business. And if Delegate Levine is there, I apologize. It's just we're going to get through the agenda. 45 minutes went by and we have to move really fast. So we're going to limit also the speakers, Clerk, to 2 minutes. So
Yes.
we can just move faster. Thank you.
Yes, Madam Chair. Delegate Levine, if you're in the room.
I am. I wasn't quite clear if I'm next. If I'm next, I'm happy to move forward.
Delegate Samira, that was my fault. Delegate Samira is actually next.
Okay.
Delegate Samira, if you're in the room, could you please unmute your microphone?
I am unmuted.
Thank you.
Hello, everybody. Good morning. And thank you so much, Madam Chairwoman and members of the committee. This bill is from the Virginia Poverty Law Center as well, a wonderful recommendation of an idea to cover all the all the children that are not currently covered by health insurance. Some of the numbers that are out there right now, 32% of Virginia's children live in one-parent households, and typically the non-custodial parent is subject to an order to pay child support. 14% of Virginia's children receive child support, and approximately 5% of Virginia's children are not covered by health insurance. That's about 52,000 eligible for Medicaid or FAMUS. Child support orders in Virginia are required to include information about healthcare coverage for children. But again, there's a gap. There's a 5% gap. So this bill seeks to fix that gap so that we have those 52,000 children on Medicaid or FAMUS. And even if they have another health insurance out there that may be worse, this is another way of strengthening their health insurance through an additional Medicaid or FAMUS coverage. That's the basic premise of the bill, and I look forward to the discussion and hopefully report out. Thank you.
Thank you, Delegate Samira. Do we have any questions to the patron before we let the public in, members of the subcommittee? All right, being none, can we? Is there anyone in the public who would like to speak in opposition or in support of this bill, Claire?
Yes, Madam Chair. Speaking first for the bill is Valerie LaRue. Valerie.
All right, thank you. And let's just remind the speakers that we have 2 minutes for each person, please. Thank you.
Thank you, Madam Chair, members of the committee. I believe there's a substitute for this bill as well. And the substitute addresses some of the concerns that were expressed to Delegate Samira from both the courts and from the Department of Child Support Enforcement. Those substitutes sought to address those concerns.
Okay, could you wait 1 second, and if someone could please move the substitute.
So moved.
Okay, it's been moved. Can we have a second?
Okay.
Madam Chair,
Second by Delegate Walker. Yes, Council.
Does the patron wish to introduce a substitute?
Yes, I almost forgot about it. Lots of work by Sarah there. So thank you so much, Sarah. Please, I'd love to move the substitute.
All right. So the substitute has been moved and properly second. And now is what you were referring, Delegate Samira, was your substitute or the original bill?
The substitute, in the amendment in the nature of the substitute that I wanted to introduce to the wonderful committee here.
All right. So you already explained us the substitute, so we don't have to go back to you. Or is there anything else that you want to add?
The substitute was a lot of just trying to clarify language for the parties that are going to be involved, so that it makes sense to them, so that they can operate in the context of this provision that would be updated on the function of the work of all the entities that are involved in making sure that FAMUS and Medicaid coverage is available to the children that go through the court system.
All right. Do we have any more speakers to speak in favor or against this bill, Madam Clerk?
Madam Chair, I don't know if Ms. Valerie LaRue finished her remarks.
Thank you. Madam Chair, members of the committee, what the substitute does is ameliorates concerns that the court had. The original bill would have required the court to determine whether the family qualified for public health coverage for the child. The substitute only requires the court just to notify the parties of the existence of that. The original bill also required the Department of Child Support Enforcement to also make a determination about the eligibility of the child. The substitute only requires the department to make a referral if the child would qualify. And I will just say that the reason why I wanted to work with Delegate Samira on this bill is that we see a lot of families who lose healthcare coverage. So in this context of child support. So for instance, if the custodial parent with the child is not the one who is paying for the healthcare coverage, but the non-custodial parent is paying. Sometimes there are lapses. The non-custodial parent doesn't pay the premium or loses their job and loses their insurance. Meanwhile, the custodial parent is struggling.
30 seconds.
So this bill would ensure that those gaps, when a family qualifies, it wouldn't make any more families qualify. It would just cover those families that are qualified. Thank you.
Thank you. Do we have any more speakers for this bill, Madam Clerk?
Yes, Madam Chair. One final speaker speaking against the bill is Eric Reynolds. Eric, if you could please enter the room.
Good morning, Madam Chair, members of the subcommittee. I'm Eric Reynolds, Office of the Executive Secretary, Supreme Court of Virginia. Court does not have a position on this bill yet, but judges of the circuit courts and juvenile domestic relations district courts have reviewed the bill, and as well as the substituted language, and recommended to oppose the bill for the following reasons. The bill imposes a function on the courts that is outside of the role of the judiciary. Courts rule on evidence that is put before them by the parties and should not speculate as to whether the families would be eligible for public health insurance programs. There are other factors for Medicaid or FAMUS eligibility than just a family's income level, and judges should not be put in the position to advise families of the availability of Medicaid or FAMUS when other factors may affect their eligibility. Promotion of programs like Medicaid or FAMUS is really a function of the executive branch and executive branch agencies. The judges that have reviewed the bill acknowledge the problem that the bill is trying to address, but disagree that this bill is a proper way to address that problem. Thank you.
Thank you. Do we have any more speakers for this bill, Madam Clerk?
Madam Chair, that was our final speaker for this bill.
All right. So we have any additional questions for the patron or any of the speakers, committee members? Okay, being none, this committee works in motions.
Madam Chair, can I ask a question of our last witness, please?
Sure, Delegate Tran.
Thank you. Thank you so much, sir. So if I understand that you believe that the courts may not, you have a different opinion as to the role of the courts, but if you had the appropriate information in front of you, would a judge be able to help provide the information, to families based on what's laid out in this bill.
Madam Chair, Delegate Tran, the courts, again, are going to be ruling on and making findings regarding child support and the obligation, how much the child support should be. And they do take into consideration various factors, of course, income of the parties, health insurance for the child or children, of course. So the discussion does take place in the court hearing about the availability of insurance for the children. But that is, again, for the purpose of deciding or determining what the amount of child support is. Whether or not a family is eligible for Medicaid or FAMUS, again, just based on the evidence put before the judge, I'm not sure that they would be able to make that determination that this family or that family would be eligible for Medicaid or FAMUS, just based upon the limited information that's provided in the context of a child support hearing.
Thank you. Do we have any additional questions?
Madam
Delegate Tran.
Madam Chair, just speaking to the bill, just a clarification piece. I don't think that the substitute requires the court to make a determination about eligibility if you are eligible, but it's just a notification that these programs are available so that those families could then pursue whether or not they're eligible and actually do the application themselves. That's how I read the bill. Counsel, if you could let me know if I have the right interpretation, please.
Yes, Madam Chair. Everyone's all moved around on my screen. Sorry. Yes, and Delegate Tran. In the substitute, it does provide that in order for healthcare coverage, including health insurance policy information, etc., written statement that healthcare coverage is not available at a reasonable cost is defined in this section period. So that's what we're going to include in the order. The new language adds, if it appears that the gross income of the custodial parent of the dependent child is equal to or less than 200% of the federal poverty level, the court shall notify the parties of the availability of medical assistance through the FAMUS plan or other government-sponsored health insurance through DMAS. So what Delegate Tran is saying is accurate. The bill doesn't necessarily state that the court would have to do the determination. Somebody will have to do the determination of the gross income. But then if it appears based on that information that it is below 200%, the court simply has to include the information about access to these programs.
Madam Chair?
Yes, Delegate Air.
Is someone here from the Department of Social Services?
Do we have still the Director of Family Services with us? All right. So please.
Okay. I'm not sure if she's in the room. I'll call on her. Barbara Lucina, are you in the room?
I am.
All right.
Good morning.
Good morning.
Hi.
Madam Chairwoman and members of the subcommittee. Barbara Lucina for the Department of Social Services in the role of Director of the Division of Child Support Enforcement.
Madam Chair, a question of Barbara, please.
Sure, right ahead. Go right ahead, Delegate Air.
Thank you. Barbara, can you help me understand the existing process for notification in these types of circumstances? So I guess I understand what this bill is trying to accomplish, but what role does social services typically play relative to notification existing?
The role that the Department of Social Services plays is one of education and information. So information is available on the Department of Social Services website. Information is available directly from any one of the program offices within the Department of Social Services. And information is also available in various formats in which the Department of Social Services is a participant, not the least of which would be in court settings where the information about the availability of Medicaid would be shared as a normal course of business.
So, follow-up question, Madam Chair.
Yes, Delegate Air.
So, to further clarify, there is not outward notification that occurs, it would rather be someone going in search of this information at this time.
Yes, I would confirm that that's an accurate interpretation, that there is not proactive campaigning about the availability of Medicaid services to the general public.
Thank you, Madam Chair.
Thank you. Do we have any additional questions to any of the speakers or the patron?
I guess I have a question of the patron.
Are you sure?
Sure.
Delegate Air, Delegate Samira, are you still with us?
Absolutely.
Thank you, Delegate Samira, Madam Chair. I guess my question is trying to clarify why put the onus on the court and not social services for this notification.
It's a great question, Madam Chair, Delegate Aird. I believe that the central place where this process begins to clear up is in the court system. The Department of Social Services is a step away from the centrality of coverage during child support hearings. And that is why the courts would be the appropriate place to address this right away, because as soon as a determination is made as to who's in charge of providing healthcare coverage to the child, there should be immediately a providing of the resource to these 52,000 children that are uninsured currently.
Madam Chair.
Delegate Aboli.
Just briefly speaking to the bill, Delegate Samir, like the other bill, my heart goes out to this. I want to support it 100%. Unfortunately, I have concerns coming from the court, and until that's clarified, I do not want to put our esteemed assembly as well as the judges in a precarious situation. I hope this can be resolved, Madam Chair. At the format it's in right now, like the other one, I've got some heartburn, even though I support it 100%, okay?
Madam Chair, if I may.
Yes, Delegate Samira.
Yes, Madam Chair. And I want to go back to Delegate Tran's question, which was really pertinent, is the court required to determine eligibility? No, it is not. If eligibility appears, then they are to offer the information that is necessary for Medicaid and famous coverage. So I think that what council had recommended, had mentioned is very pertinent as well. Yes, there's, nobody wants more responsibilities for sure, but there is no more responsibilities being added to the court system as it currently stands, as the council and as Delegate Tran had mentioned. So I do not think that this is pushing anything on the court that is to be considered here as part of the clarification. And I do think it's important to note that the courts have not taken an official position. That was the first thing that Mr. Reynolds had mentioned. So I would hope that all that information is taken into serious consideration. Thank you.
Thank you, Delegate Samira. Any other question for the patron or any of the speakers? If there's none, this committee works by motions. Okay, we don't have a motion, Delegate Samira, unfortunately. Delegate Sickles?
If there's not a full committee here, I would move the bill if I'm eligible to make that motion.
Move to report.
Okay, so move to report and seconded by Delegate Air. Is that accurate?
No, I think Delegate Air moved it and Delegate Samira seconded the motion.
No, Delegate Samira.
Delegate Tran will second the motion.
Okay, Delegate Tran will second the motion. Clerk, please open the roll.
Delegate Air. Madam Chair, all members have voted. Oh, Madam Chair, this is actually report with substitute.
Yes, it's a report to substitute. So Chairman Sickles, we need to restate the motion.
I made the motion. I move to report the substitute.
Thank you, Delegate Aird. And it's seconded by Delegate Tran. So clerk, please open the roll.
Madam Chair, all members have voted.
All right, clerk, close the roll. So this bill is moved to full committee on a vote 3-2. Thank you, Delegate Samira.
Thank you, Madam Chairwoman.
Yes, so we are going to take care of Delegate Austin. We heard earlier that he's going to strike the bill, and that is going to be a recorded vote. Can I have a motion for the House Bill 2289?
Madam Chair, I move to strike the bill. 2289.
Second.
All right, thank you. It's properly motion and seconded. Madam Clerk, would you open the rolls to strike the bill? Okay, the bill is stricken in a vote 6-0. Thank you, Madam Clerk. Please close the roll. All right, the following bill that we have, it's going to be Delegate McGuire. Is Delegate McGuire with us, Madam Clerk?
Yes, Madam Chair.
Yes, I'm here.
Good morning, Delegate McGuire. So tell us about your House Bill 2086.
Hey, good morning. Thank you, Madam Chair and members of the committee. House Bill 2086 is a background check portability bill, and it has bipartisan support to help create a substitute teacher pool. I think we all know we have a critical teacher shortage in the Commonwealth, and I've been working on this for about 3 years with other folks, and it's nice to see State Senator Jennifer McClellan with the exact same bill. I guess I got to back up. I got to move a substitute.
You answered the call. I thought I pushed the red button. Okay.
Delegate Aboli, could you mute your microphone? Sorry about that, Delegate McGuire. Go ahead.
I'm sorry.
So,
Apologies.
So, Madam Chair, I moved the substitute. I forgot if we agreed on that.
I move the substitute, Madam Chair.
Okay, we have a substitute before us, moved by Delegate Tran. Do we have a second?
Second.
All right, second by Delegate Aboli. The substitute is before us. Delegate McGuire.
And so what the substitute does is it adds a voluntary pilot program to help make sure that students are provided the best service under this idea. And right now with teacher shortage in Virginia, if a teacher, a substitute teacher for early childhood development, for example, works at one daycare on Monday, and she goes to a different daycare on Tuesday, and then a different daycare on Wednesday, she has to have 3 different background investigations. So this bill, we've worked with a lot of stakeholders. It allows them to do one investigation. It saves them money, saves time, and it helps us with the teacher shortage. And I think we have a lot of people that want to speak to it.
All right. Do we have any questions to the patron before we let the public speak? Members of the committee? All right. Being none, Madam Clerk, could we allow the public to speak? Thank you.
Yes, Madam Chair. Speaking for the bill, we only have 2 people, and the first is Grace Reef. Grace.
Hi. Good morning. I am Grace Reef, and I'm with Child Care Aware of Virginia. We're a nonprofit that works statewide to support families finding childcare and provider training, childcare centers and family childcare homes. We are very happy to support Senator McGuire's bill. Quite frankly, the public schools, if a teacher calls out, they are able to tap into a subpool, and we think childcare providers ought to as well. Particularly now during COVID, there's a need for subs. So I just want to say thank you, Delegate McGuire, and I hope the subcommittee will approve the bill.
Thank you. Can we get the next speaker, please?
Yes, Madam Chair. Our next and final speaker is Abigail Ferris Rogers. Abigail?
Thank you for having us today. I represent the 27 YMCAs from across the state of Virginia, and we're in support of this bill. You know, we're currently serving thousands of kids with virtual learning right now, as we have for emergency childcare through the pandemic. But we are also one of the largest childcare providers in the state of Virginia, and this bill would be very helpful for us as we share staff across associations here in Virginia, but also as we are constantly trying to hire staff and have a staff shortage. The background checks can slow down the process of having staff to start. They can take 2 to 10 days to be able to get that information back, and we are working with a shortage of counselors and providers right now as it is. So we would appreciate this possibility. We fully believe in background checks, and the safety of our kids is very important, but being able to move them around when you already have one will save money for providers as well as ease the hiring process. Thank you very much.
Thank you. Do we have any additional speakers, Madam Clerk?
Madam Chair, that was our final speaker.
Thank you. Do we have any questions to the patron or any of the speakers, members of the committee? Okay, being none, Delegate McGuire, would you like to give any additional closing remarks?
If appropriate, I see we have Kim Holter there with the VCCA, and I believe she wanted to speak. Is it okay if she speaks?
She signed up?
Yes, she is signed up. I did not get a notification that she was in the room, but if she's in the room, Madam Chair.
Yes, go ahead.
Okay. Ms. Kim Holter.
Hi, thank you, Madam Chair, members of the committee. Yes, my name is Kim Holter. I'm the Executive Director for the Virginia Child Care Association, and we fully support House Bill 2086, largely based on the workforce shortage that we're experiencing. And we would just like to have as many teachers in this field as possible, and we need a substitute pool right now to be able to help with the shortages. So we ask that you please consider this bill.
Thank you. All right, I think we heard all of the speakers. Do we have to make any additional questions to the patron? Chairman Sickles, are you speaking with us? I don't think he is. All right. This subcommittee work by motions?
So moved, Madam Chair.
And these, all right, and this bill will have to be referred and report to appropriations. Is that accurate, Council?
Madam Chair,
No, right? No, sorry, I confused.
Yeah, I don't think this one does. If
okay.
Some different information we'll find out before the full committee meeting.
All right, so the bill has been reported and seconded. Clerk, please open the roll so we can cast our votes.
Chair, all members have voted.
All right, please close the rolls. The bill is referred to full committee 5-0. Thank you, Delegate McGuire.
Thank you, Madam Chair, members of the committee.
Thank you. Delegate Tran, why don't we look at your bill 2035?
All right, thank you so much, Madam Chair. I do have some amendments.
Now you can play the game.
And I don't know if Council Prima's amendments are as
everywhere
or as a substitute.
Sure. Do we have a motion to move those amendments? I moved the amendment. Can I have a second? All right, I think it's been seconded by Delegate Aird.
Yeah, I'm sorry. I said so moved, and then you said move. So yeah.
Okay, that's fine. We are just trying to multitask, all of us here. So Delegate Tran, the amendments are before us.
Thank you so much, Madam Chair. And the amendments, let me just speak to them briefly, help to clarify the intent of the bill, which is that when you are during the 6-month period of subsidized employment, that the wages that are earned during that period do not count towards the TANF eligibility and the benefits that are going to be received. But let me just start off more broadly about what this bill does. Is it increases opportunities for subsidized employment for TANF recipients. Subsidized employment, as you may know, is a really good strategy to help some of our most vulnerable individuals be able to gain work experience while getting paid and getting the supports that they're needed so that they are then able to transition to unsubsidized employment. Particularly as we are looking at our economic recovery from this pandemic, we want to make sure that we leave nobody behind. And as there's more and more competition for jobs that are going to be opening back up, right? We want to make sure that individuals who are on TANF are able to have the skills and the on-the-job experience that they're going to need to be able to compete as the economy picks up. So we want to make sure that some of our most vulnerable Virginians are included in our economic recovery. So this bill increases the amount of funding available for the subsidization to $1,000 per month for a maximum of 6 months. And the TANF recipient will continue to receive their monthly TANF benefits in addition to any income earned from this job. Sorry, you hear the soundtrack of my life in the background. So I will stop there in case you have any questions. I know folks from DSS are also available to answer questions.
All right, do we have any questions for Delegate Tran, members of the committee? All right, being none, Madam Clerk, do we have anyone who would like to speak in opposition or in favor of this bill?
Madam Chair, we have 2 members speaking in favor of the bill. The first is Mark Golden. Mark.
Hello, Madam Chair and members of the subcommittee. My name is Mark Golden, and I am the TANF Program Manager at the Virginia Department of Social Services. HB 2035 is an administration bill, and we strongly support it. The Full Employment Program provides employer subsidies for hiring and training TANF recipients. There are several areas in the Full Employment Program that, if addressed, will greatly improve it. The current employer stipend is too low and does not attract employers. TANF recipients are reluctant to participate because they lose their TANF benefits. Case managers are reluctant to assign participants to the program because people that do not receive a payment are excluded from the calculation of the state's work participation rate. In other words, staff don't receive credit for these placements. And finally, case managers find it difficult to devote the time necessary to recruit employers. This legislation addresses all of these issues by increasing the employer stipend, allowing the participant to retain TANF benefits, including funding for 2 job developer positions. Funding is included in the governor's introduced budget. I urge you to support HB 2035. Thank you.
Thank you. Can we invite the second speaker, Madam Clerk?
Yes, Madam Chair. Our second speaker and final speaker is Chloe Edwards. Chloe.
Good afternoon. Thank you, Madam Chair and members of the committee. My name is Chloe Edwards with Voices for Virginia's Children. We're home to the Racial Truth and Reconciliation campaign with over 400 coalition members in the support of Virginia's trauma-informed community networks. In 2019, over 245,000 children in Virginia lived in poverty. We know that COVID-19 also widens racial and ethnic disparities. Our Kids Count data center indicates that poverty rates of 26% for Black households, 18% for Latinx households, and 8% for non-Hispanic white households. While the pandemic is a trauma, economic trauma refers to stressful impact or emotional pain that stems from a lack of financial opportunities, such as poverty. There are numerous barriers to employment for families, such as transportation, education, childcare, the benefit cliff, and economic downturn. Please support this bill, an opportunity for families to reach financial independence. Thank you.
Thank you. Well, we have heard the speakers. Do we have any questions for the patron of any of the speakers? Being none, this committee would entertain a motion.
Move to report.
All right, it's been reported by Delegate Aird, and I second the motion. Clerk, please open the roll.
Delegate Avoli?
Aye.
Delegate Avoli votes aye. Madam Chair, all members have voted.
All right, Delegate Trent, your bill has been referred to full committee and a vote 5-0. Thank you. Well, the last bill on the agenda is Delegate Levine. Delegate Levine, House Bill 1932. Thank you for your patience. We just got notified that there are at least 22 speakers who have signed up to speak either in opposition or in favor of this bill. So it is 12:18 and we need to conclude our business before 1 o'clock. So I think that we are going to have to limit the speakers to 1.5 minutes in order to get them all to speak, if I'm doing the math right, so we can finish our business before 1 o'clock. So Delegate Levine.
I will be extremely brief. Thank you, Madam Chair and members of the subcommittee. HB 1932 is actually a very simple bill. All it does is repeal a section of the code, 63.2-1709.3, that I think is inaptly called the Conscience Clause. This was put in 2012 with express purpose of having Virginia fund taxpayer discrimination. Is largely focused at the gay and lesbian community, though I should note that the bill allows all religious discrimination to be funded by taxpayers. It could be against any religion whatsoever, could be refused under this. Prior to 2012, there was no such law. There were many long-term licensed child placement agencies that place children for foster care and adoption. The vast majority in Virginia do not discriminate, but the ones that did and the ones that didn't were all allowed prior to 2012. It's a very unusual law. Only a handful of states have it. More than 40-something, including some very conservative states, do not have this law. So repealing it merely puts us in a position we were before 2012, where you can have discriminatory agencies or non-discriminatory agencies funded by the Commonwealth. Last year, I put forward this bill. It was a little stronger last year. It repealed this law and it required non-discrimination for the future. This bill is more modest than last year. It simply repeals the requirement that Virginia fund discrimination. Now Virginia could decide whether or not to fund discrimination. And at the appropriate point, I'm happy to introduce an enactment clause as an amendment that would allow the grandfathering in of those under the old regime for another year to allow time to transfer if necessary. But with that, I'd love to have the people, there's a large group of people, as you can see, that want to speak to this, and I'd like to let them have their say.
Delegate Levine, I heard you saying that you have an amendment to the bill?
I do have an amendment. I'm happy to offer it now if you like. It is at the desk. I've submitted it. The council has it. And what it does is it says that basically folks that are under this current regime right now can have until January 1st, 2022, that those families, and that would give, I think VDSS will say that that's plenty of time for them to do any transitions that they need to do. It's an enactment clause. I could read it, or council could read it, but it's basically an enactment clause, a grandfather clause.
Thank you, Delegate Levine. So, Council, do you have anything to add?
Would you like me to read the amendment? It is available online. I can read it if you want.
Okay. No, we're good. I think that Delegate Levine explained it really well. So, amendment is before us. Can we?
I move the amendment, Madam Chairman.
Second. All right, the amendment is adopted. So now House Bill 1932 is amended. If we can, any additional remarks, Delegate Levine, before we allow the public to speak?
I'd like you to hear from the public. Thank you, Madam Chair and members of the subcommittee.
Thank you, Delegate Levine. Madam Clerk, so can we allow the public to participate? And I apologize to the public, but we're going to have to limit those remarks to 1.5 minutes. So everyone who signed up has the opportunity to speak. Thank you.
Yes, Madam Chair. We have starting 13 people speaking for the bill. The first person is Megan Lane. Megan, please enter the room and unmute your microphone. Megan, please enter the room and unmute your microphone. Madam Chair, would you like me to move to the next speaker?
Yes, please.
Sorry, I'm here. I'm sorry.
Oh.
Hi, my name is Megan Lane. I am the Program Director for Catholic Charities Pregnancy and Adoption Support. We serve the Diocese of Arlington, Northern Virginia, and surrounding areas. What I would like to say about this bill is just that I understand that the sponsor has said that the intention is very simple. However, as an agency, we provide adoption services for children who are in foster care in Virginia. Also outside of Virginia, we do infant adoption, and we also do foster care adoption only for families who want to adopt from foster care, not as a foster care agency in Virginia necessarily. So all of these services that we provide, they're not state funded. You know, we just require our license to continue. We have been providing services since 1947, and we do hope to continue those services. And so for me, I just want to make it clear that while the language is being said that this will not impact our ability to remain licensed.
30 seconds.
That is absolutely not my understanding. I've been working in child welfare in Virginia on the public and private side for over 10 years. This absolutely affects the licenses of faith-based agencies. And there's a Supreme Court case pending right now, which will set federal precedents. And I would ask the committee to wait at least until we see what the Supreme Court says about this decision. Thank you.
Thank you, Megan. Next speaker.
Madam Chair, next speaker is Allison Gilbreth. Allison.
Good afternoon, Madam Chair, members of the subcommittee. Allison Gilbreth with Voices for Virginia's Children. We are in support of this legislation. First, we want to acknowledge that we want to ensure that as many children in Virginia have the opportunity for foster and adoptive homes. And we also want to make clear, because there might be testimony later on, that this will not risk the placement of any child currently in Virginia. And that is extremely important. And I want to ensure that that no child during this hearing feels that they are ever going to be at risk of being removed from their home because of the passage of this bill. But I want to defer my time to others in this subcommittee hearing.
Madam Chair, our next speaker is Matthew DeGrave. Matthew, could you please enter the room?
Hi, good morning or good afternoon, everybody. Can you hear me okay?
Yes.
So I'm actually speaking for myself and, I'm sorry, I guess I should say good morning, Madam Chair and members of the House and Health and Welfare Committee. As a Virginia resident and an assistant state director for American Atheists, which has over 1,600 constituents in Virginia, I testify in support of HB 1932, a bill that would end state-sanctioned discrimination in foster care and adoption based on religious beliefs. Every young person in Virginia deserves a loving home. This legislation would increase the number of available foster and adoption families, leading to a more availability for children in foster care to have loving, permanent homes. We strongly urge you to support this bill. Religious liberty is guaranteed by the First Amendment to protect individual beliefs. It does not create special rights for religious individuals and organizations to violate neutral laws or discriminate against groups they disfavor.
30 seconds.
Nationwide, there are over 400,000 children in foster care system. There are 5,000 children in foster care in Virginia, and just over 2,000 of these are either in long-term foster care or waiting. Nationally, 24,000 children will age out of the foster care system with no support at the age of 18. Furthermore, 20% of the youth will age out of foster care to become homeless. Youth in Virginia child welfare system are already at risk. Their ability to find permanent homes shall not be endangered.
Time has elapsed.
We strongly urge you to support the bill.
Madam Chair, our next speaker is John Calhoun. John. John, please enter the room and unmute your microphone. Madam Chair, our next speaker is V. Lamneck. V.
Thank you. Good afternoon.
Here I am. Madam Chair, I speak as former United States Commissioner of the Administration for Children, Youth, and Families, where I played a major role in helping to pass 96-272, the Child Welfare and Adoption Act of 1980, which stressed finding and strengthening family strengths and not finding them in immediate or extended family, moving swiftly to adoption. Permanency and a loving home were the principles. Loving, courageous, committed adoptive families are hard to find, and thus I'm in full support of this bill, which would widen the net to find such families willing to adopt. I also served as Commissioner of Youth Services in Massachusetts in the late 70s, and there also stressed family support for delinquent kids, and that failing that, moving to adoption. It was tough to find adoptive parents for many of these kids as they were wounded, angry,
30 seconds.
and traumatized. So anything you on the committee can do to expand the reservoir of loving, competent folks ready and willing to adopt, I applaud. Thank you.
Madam Chair, our next speaker is V. Lamnick.
Thank you. Good afternoon, Madam Chair, members of the subcommittee. My name is V. Lamnick. I'm the Executive Director of Equality Virginia, and we support HB 1932. As you have heard, in Virginia and across the country, LGBT couples and individuals frequently make the decision to provide a home to a child through foster care and adoption. In fact, LGBTQ couples are 7 times more likely to foster and adopt than straight couples. However, here in Virginia, the Conscience Clause makes it possible for private child placing agencies, which are government funded and contracted, to turn away LGBT individuals and couples. Not only is this discriminatory towards LGBT adults seeking to foster and adopt, but it sends the message that our government isn't doing everything that it can to place children in loving and supportive homes. This is extremely problematic because, as you've heard, Virginia has one of the highest rates in the country of children aging out of care. Simply put, we need more families who are willing and able to adopt kids, not less. At the end of the day, HB 1932 helps to achieve just that. It would lead to improved outcomes for children and parents in the adoption and foster care system across the Commonwealth. Thank you for your support.
Madam Chair, our next speaker is Mary Ramiller. Mary.
Good afternoon, Madam Chair and members of the subcommittee. I'm a resident of Virginia and also co-director of state policy for family equality. I'm co-chair of the Every Child Deserves a Family campaign, which is a coalition of over 700 individual, state, and national partners in the faith, child welfare, and civil rights communities. And I'm speaking in support of HB 1932 because in the midst of this worsening childcare crisis in this state where too many children are left in congregate care and age out of the system, Virginia has a law in place that deters LGBTQ families who want to open their homes to foster children. Considering the historical discrimination against the LGBTQ community in all facets of life, you can't assume that an LGBTQ couple will simply make the leap of faith and make the call to an agency when they know they live in a state that allows them to be rejected, not because they don't meet the state criteria, but because of who they love. We just heard earlier in this hearing about the importance of kinship placements to the well-being of children. Agencies can even refuse to place children who have no control over which agency they are assigned to with LGBTQ and religious minority kin under this law, which is simply unconscionable. This law does not require any agency to close. There's many states that do not have a law like this, and faith-based agencies continue to operate in harmony with those states. And we do not need to wait for Fulton because that implicates a non-discrimination law, which is not an issue here in this bill. Please pass this bill to put kids' interests ahead of agencies. Thank you very much for your time.
Madam Chair, our next speaker is Deborah Hawkins. Deborah, please enter the room and unmute your microphone.
Good afternoon. My name is Deborah Hawkins, and I'm here to speak of advocacy for the Virginia Council on LGBTQ advocacy, and also for myself professionally as a licensed marriage and family therapist. I'm here to speak for the LGBTQ youth who are way overrepresented in the foster care system. I'm not sure you all understand that at least one study in 2019 showed that over 30% of the youth in foster care identify as LGBTQ and 5% is transgender. So of our thousands of kids that are in the foster care system in Virginia, more than half are over 10 years old. So these kids are struggling with their identity as teens, preteens, and even we know even some children as young as 3 are already dealing with their feeling of not representing their of gender identity issues. So this is a really important time for kids and for them to be placed in homes which do not respect their choices and may not support their identity growth. It's really traumatizing. All these kids are already traumatized just by being in the system, and there are really quite a few of them. So even if 90% of the placements were wonderful, even 10% represents about 150 or more kids every year in Virginia who are going to have issues. It's probably much more than that. So what do? They act out.
30 seconds.
They're going to be suicidal, and what happens is they run away and they're often homeless. So one study showed that 40% of the homeless youth identified as LGBTQ. In New York, one study had 78% of the youth were removed or ran away from foster homes because of hostilities they faced. 56% chose to live on the street rather than a foster care placement because they felt safer there. So we need to do something about this. I want you to, I'm speaking for the kids. I want you to speak for the kids and vote yes on HB 1932. Thank you.
Madam Chair, our next speaker is Jennifer Surratt. Jennifer.
Greetings, Madam Chair and members of the subcommittee. Thank you so much for allowing me to speak in support of House Bill 1932. I am the Director of Programs for C2 Adopt, which is a local nonprofit licensed child placing agency. We work with all types of adoption, but a significant portion of our work is working with foster youth in need of permanent, loving adoptive families. Y'all have already heard many of the statistics about what happens when children do not have the opportunity to live in families or age out of the system. It is therefore harmful practice to turn away any family who may be an appropriate foster or adoptive family for our youth. Not every Christian family is appropriate. Not every LGBTQ family is appropriate. Not every single parent is appropriate, and so on and so forth. But to make prejudicial decisions as to their qualifications prior to a full, thorough assessment process creates barriers to address the very real need for increased foster and adoptive resource families. In addition, the needs of our youth are varied, and some youth are best served in one family versus another. We need families who are diverse and capable, who can meet the needs of all different types of youth with all different types of needs. Again, we create harm when we limit the pool of available families before the appropriate assessment. Thank you for your time. I urge you to support HB 1932.
Madam Chair, our next speaker is Alex Wagaman. Alex.
Good afternoon. Thank you, Madam Chair and members of the committee. My name is Dr. Alex Wagaman, and I am co-chair of the Youth Housing Stability Coalition here in Richmond, which has over 30 organizational members and works collectively to create the conditions that would allow us to end youth homelessness in the greater Richmond region. I'm here to ask you to vote in favor of HB 1932, which we believe will help us in the effort to end youth homelessness. Based on a national study, up to 1 in 3 youth experiencing homelessness in the US have foster care experience, and youth in care are particularly vulnerable to experiencing homelessness in young adulthood when they age out of foster care prior to being adopted or finding permanency. In addition to expanding the pool, we also see the repeal of this conscience clause as being essential to allowing LGBTQ youth to see themselves reflected in those who may be caring for them. This sends an important message about their worth and will ultimately alter how they're treated in the child welfare system. Essentially, with more families and stakeholders involved who understand the needs and experiences of our LGBTQ young people, they will be more likely to find permanency and affirming. As a young person told me last night who works with our coalition, she said, imagine, Alex, if I had seen people like me, LGBTQ people, in my time in foster care. Imagine how much more confident and self-assured I would have been as I entered into my young adulthood. I urge you to vote yes on HB 1932 and affirm our commitment to LGBTQ families and children as a Commonwealth. Thank you.
Madam Chair, our next speaker is Sharon Reams. Sharon.
Hi, my name is Sharon Reams. I'm the Director of Youth Services at the UP Center. The UP Center is a local nonprofit licensed child placement agency in Virginia, providing foster and adoptive services. We've been providing services to families in Tidewater for over 130 years. We are in support of the House Bill 1932. Virginia needs more families who can provide homes for children in care, not more agencies refusing to place children in qualified homes. The kids in care have very diverse needs. The pool of parents should reflect that diversity in order to best meet their needs. And we are in support of the House Bill 1932.
Madam Chair, our next speaker is Amanda Silcox. Amanda.
Good afternoon, Madam Chair, members of the subcommittee. I'm Amanda Silcox, and I'm the legislative coordinator for Rise for Youth. We support House Bill 1932 and urge you all to do so as well. Only 9 other states in the entire U.S. have this so-called conscience clause, and removing the clause would not require anyone to, forget or leave behind their faith while they go through the fostering and adoption process. There are faith-based agencies that are still willing and able to work with families of faith through this process without the conscience clause. And furthermore, as a person of faith myself, I urge you to support this bill. Thank you.
Madam Chair, our next, starting the speakers to speak against the bill, and our first speaker speaking against is Jeff Caruso. Jeff, could you please enter the room and unmute your microphone?
Thank you, Madam Chair, members of the subcommittee. Jeff Caruso with the Virginia Catholic Conference. We have 3 Catholic charities agencies whose services span Virginia. Each one serves families of all faith backgrounds. They add tremendous value to Virginia's child welfare system, which needs all hands on deck to succeed. The current law was created for very serious reasons. In 2011, groups, including one that testified today, made a push at the Board of Social Services to end licensure for agencies with our beliefs. After months of debate, proposed regulations even came to a vote at the Board of Social Services, but were not adopted. It was only after this attempt to end our licensure that we asked for these conscience protections at the General Assembly in 2012, so this wouldn't happen again. In other words, to make sure that the status quo would continue and a diverse array of providers could serve a diverse array of families and prospective parents. The law says that child placing agencies are not required to participate in placements that would violate their beliefs.
30 seconds.
They cannot be denied a license because of their not participating in these placements, and they cannot be denied state grants or contracts because of this. Section C on denying state grants or contracts is what Delegate Levine is focused on. He wants to take away state funding from Catholic charities. If you do away with Section B, which has to do with the licensure, we could very well be right back at the Board of Social Services again. These are complex issues, so complex that the U.S. Supreme Court is going to be making a decision
Time has elapsed.
on this very issue later this year. And for that reason, as well as the lack of stakeholder discussion, we would ask that this bill not move forward. Thank you.
Madam Chair, this is Delegate Tran.
Delegate Tran, do you have a question to the speaker?
I do have a question for the witness. May I please ask?
Okay, sure. Go ahead, Delegate Tran.
Thank you. And thank you for being here today. I was looking, when you look at the bill, it just says repeal, right? It's hard to, you have to look at what is the underlying code. And I was I have it up right now. And I would really appreciate kind of your perspective in terms of what are next steps for Catholic charities if Section D is repealed. Would you continue to operate in Virginia, or would you, do you think you would pull out entirely?
So are you, just for clarification, are you referring to Section B that has to do with licensure? So The law says four things right now. It says that we do not have to participate in placements that would violate our beliefs. That's Section A. Section B says that we cannot be denied a license based on not participating in those placements. Section C says we cannot be denied state grants or contracts based on not participating in those placements. And Section D says we cannot be sued if we do not participate in those placements. I think Section C is what Delegate Levine is focused on. He's told you that last year at the hearing. And again, he's telling you that this year. He's even laying out details for what he hopes the timeline will be if indeed our funding comes to an end. Section B, which has to do with licensure, if you do away with that, it opens the door for there to be another push at the Board of Social Services to end our licensure. And if we don't have licensure, then funding or nothing else is really even an issue at all. We could not continue to practice if we cannot adhere to our beliefs.
Madam Chair, if I may have a follow-up.
Sure, Delegate Tran.
Thank you. I apologize. I was confusing. It's the whole section. So it would be A, B, C, and D is I think what would be repealed in currently in the bill. But my understanding is unlike last year's bill, this year Delegate Levine is just repealing and doesn't make a proactive statement in terms of what the agency can or can't do in its place.
Madam Chair, may I respond to that?
Sure, Mr. Caruso.
Thank you, Madam Chair. And Delegate Tran, thank you for the question. Again, this opens the door. If you delete Section C, it says that then the state could deny a contract or state funding, which is Delegate Levine's stated intention. He's told you that both last year and this year. And in fact, he's added an enactment clause to lay out a specific timeline for his hoped outcome of denying the state funds. Secondly, if Section B were removed, which again deals with licensure, that opens the door to us having the exact same debate at the Board of Social Services that we had back in 2011, where we were almost regulated out of existence. And that debate could very well happen again. There could be another push like that.
Thank you, Mr. Caruso. Madam Clerk, can we bring the next speaker?
Yes, Madam Chair. Our next speaker is Jay Brown. Jay, could you please enter the room?
Madam Chair and members of the committee, Jay Brown from Commonwealth Catholic Charities. We are advocates for children and believe firmly that the child welfare system is in dire need of more foster and adoptive families who can provide safe homes for children who are engaged in the system. To that end, we are working in communities across the Commonwealth to recruit and train more families who are willing to provide vital stability for Virginia's most vulnerable children. We not only provide foster care and adoption services to children born and raised in Virginia, but also to unaccompanied refugee minors from across the globe who now call Virginia home. While our practices are regarding parent recruitment are guided by the beliefs and teaching of the Catholic Church, no family is prevented from participating in the child welfare system because of our practices. If we learn that any family is outside of any of our eligibility criteria, we ensure they are referred to a provider that can serve them. We do not require that any family be a member of a particular or any faith community, and there is no child in Virginia that we are unwilling to serve. We believe that the impact of repealing the conscience protection will ultimately result in fewer licensed agencies and consequently a smaller pool of foster and adoptive homes available to serve our children. We believe there needs to be more activity in this space and not less, more recruitment efforts and not less. We need to have a more inclusive effort to promote the legitimate policy aim of increasing the availability of stable placements for children involved in the child welfare system, while at the same time allowing for a plurality of beliefs that animate a common goal of serving all of Virginia's children. Thank you.
Madam Chair, our next speaker is Renee Lewis. Renee.
Good afternoon. Thank you, Madam Chair. I'm Renee Lewis, along with my husband, Brian. I founded America World Association for Adoption. It's a Christian, international, and domestic adoption agency that's been headquartered in Virginia for over 25 years. I'm also the mother of 5 children, 4 of them by adoption. We founded this agency to help other couples and follow our belief that all orphan and vulnerable children should be loved, cared for, and have an opportunity to be in a faithful Christian home. I ask you to please oppose HB 1932. I assume the underlying argument for passing this bill is that doing so would lead to more families fostering or adopting. However, let me remind you that no one who wants to adopt or provide a foster home is currently prohibited from doing so. There are agencies that serve families from all backgrounds and beliefs throughout the state. There are 159 private child placing agencies in Virginia. This, in addition to the 121 individual branches of the Department of Social Services throughout Virginia that also offer foster care and adoption services. Protecting faith-based adoption and foster care providers does not interfere with other agencies serving clients of other faith backgrounds and beliefs. On the contrary, HB 1932 will force faith-based organizations to close their doors. In no uncertain terms, this bill will drive faith-based organizations out of the adoption and foster care system, and as a result, hurt tens of thousands of orphans and families.
Time has elapsed.
America World Adoption places orphan children into loving Christian families. Please help us fulfill our mission and serve the needs of orphans. Thank you for your time.
Madam Chair, our next speaker is Kimberly McCullough. Kimberly.
Hi, thank you, Madam Chair and the subcommittee. My name is Kim McCullough, and this is my husband, Alan. We lead a church in Herndon, Virginia, and we are foster and adoptive parents. We work with Fairfax County Family Services. We believe that the repealing of this clause will effectively shut many organizations down and create unnecessary red tape for families to help vulnerable children. If the goal with repealing this clause is to prevent discrimination, I don't believe the answer is eliminating the ability for organizations to operate in alliance with their convictions. If the goal is inclusivity, a better solution would be to create more seats at the table and pave the way for more organizations to do this work so that more families can help. Diversity in this work will be advanced by creating more opportunities and not less. I speak as someone who works directly with the county government to help vulnerable children. We've been licensed foster parents for 6 years. We've worked with many county social workers, and the common thread is that they're utterly exhausted, they're overworked, there's a huge caseload, and there is a constant need. We need more people in this fight, more organizations doing this work.
30 seconds.
Government, private, and faith-based organizations need to be working together for the good of the children. As a family on the front lines, working with the county government, we see that the amount of the work that needs to be done and the children that need to be helped, and therefore we recognize that there needs to be more seats at the table and not less. Let's not create policies that will make it harder for organizations to do what needs to be done to equip families. If this clause gets repealed, you will be creating more hurdles for organizations.
Time has elapsed.
By asking religious institutions to change their values and morality, and that is not the role of our government. By eliminating pathways for families to help vulnerable children, the only people losing are the children. So we urge you to oppose this bill.
Thank you. Next speaker, Madam Clerk.
Yes, Madam Chair. Our next speaker is Renee Lewis. Renee.
I just spoke.
I'm sorry, yes.
Yes, she just spoke.
Twice. Our next speaker is Todd Gackey.
Thank you. Thank you, Madam Chair, members of the committee. Todd Gackey on behalf of the Family Foundation. Let me just say there really is no better or longer serving public or private partnership than the one the Commonwealth has with these private agencies, these faith-based foster care and adoption agencies. For years, they have provided a majority of placements in Virginia. And having a variety of placements to choose from, those with or without faith-based mission, is good for a pluralistic society. It's good for a state that relies greatly on these dedicated faith-based agencies. And so forcing them to, kind of have to choose between their own missions and distinct calling or these regulations and licensing requirements is going to put a lot of pressure on them. But I also want to just kind of get down to a more personal level. My wife and I we went through therapeutic foster care training 6 years ago at a faith-based agency, which means that we care for children with severe traumatic or emotional experiences. And during that training, we were asked, hey, are you ready? What are you going to do when they put a hole in your wall? What if they begin to verbally lash out? And are you ready for those countless hours of going to FAP meetings and therapists and court hearings? And to which we said, yes, we're going to love them. We'll patch that hole together. And that is just in the essence of faith-based Christian agencies and parents who feel called to this ministry. Repealing this conscience protection would ultimately be a great setback to the already stressed foster care system. So I hope you will oppose HB 1932.
Madam Chair, our next speaker is Vic Nichols. Vic.
Yes, thank you. Delegate Levine introduced HJ 618 that, paraphrase, condemns all forms of discrimination that target people on the basis of religion. And then we have this bill. Can you explain that one? Some Christian groups like the UCC are into social and environmental justices and accept homosexuality. There's at least 26 churches in Hampton Roads alone if you look at gaychurch.org. With Delegate Levine admitting there are just a few places, why can't the few left take care of their small niche market? It really doesn't need a law. How many persons were actually harmed by not being able to adopt elsewhere? A good number of kids, as you heard, are in the system. Let them choose the atmosphere they want. Have we asked Muslim-based groups whether they're on track with this? And this is all coming from someone who received death threats from so-called Christians because I said the way they were acting to LGBT groups is in a non-biblical way. Thank you.
Madam Chair, our final speaker is Matt Coffin. Matt.
Hey, good morning. I rise in opposition of this repeal, and I'm here on my own accord. I'm a firefighter professionally. I've also graduated of U of R, VCU, and I have a family of four, three of which are at-home learners. We have a fourth smaller child, but I just rise to say this. What are the success rates of these faith-based partners that are in this public-private partnership? Has that even been examined? I was thinking that it was just an oversimplified call for repeal, but Delegate Levine mentioned the word regime, and in that verbiage, it has taken a whole, now I'm taken back by the oversimplified repeal, because it classifies all of these public-private partners that are basically conduits for folks who identify with that, value system so they can navigate and fulfill that desire to get these kids a home. There's 700 of them pending right now. There's over 6,000 in need. If we're going to call these public partners regimes,
30 seconds.
I would question the motives of the bill as it relates to certain Muslim groups, certain Christians, and Catholics that are using the resources available to basically give a kid a home. I'm just asking you folks, I rise in opposition for a very good reason. And if these folks are regimes that are trying to provide loving homes, I question the political nature and roots of this repeal here. I really do. Thank you for your time, and thank you folks for your service during this time from the frontline public safety community. I appreciate you guys. Thank you, Delegate Levine.
Madam Chair, that was our final speaker.
All right, so we concluded and we have 4 minutes left. Do we have any questions for the speaker? If we don't, we can entertain a motion.
Madam Chair, this is Delegate Walker.
Thank you, Delegate Walker. Thank you for the promotion, but I'm just Madam Chair for now. Go ahead, Delegate Walker.
Okay, so we heard this bill last year. What I have concerns here is that I think we have a proposed bill that is trying to fix something that's not broken. These faith-based organizations.
No, everything is broken.
I have the floor, please. We are trying to provide service for approximately 5,000 people that I understand that are looking for a loving home. Faith-based organizations have been doing a great work for many, many years. And I heard somebody mention the fact that there's some, before the Supreme Court, there is a case being determined out of Pennsylvania regarding this particular issue. So why do we need to act on something right now that we could wind up later being in violation of a Supreme Court? So I would move that we not support this bill today, Madam Chair.
Okay. Thank you, Delegate Walker. Do we have
motion?
Second, so are you moving to report the bill, Delegate Walker, and Delegate Aboli is seconded? Is that what I understand?
I'm moving that we not report the bill, Madam Chair.
So you have to get a proper motion. So that is not a proper motion. So we either report the bill, and there are other two options, but I am just unclear of what is your desire.
Okay, I'm voting against the bill.
Madam Chair.
Yes, Mr. Chairman, Delegate Sickle.
Yeah, if that is a motion not to, we have motions to table bills, to PBI bills, but we don't have a motion not to report. So, maybe the gentleman wants.
I would move the table, Mr. Chair.
So I would like to speak to the motion. Oh, actually,
yes.
Actually, Madam Chair, I want to speak to the motion, which I oppose. Hope everyone else opposes, but I wanted to, because of my understanding of this bill, and I wanted to ask council, that a lot of representations have been made here about losing licensure if they don't get a government subsidy. I thought this bill, can you explain how people can make that connection in this bill? Does the bill do that?
Madam Chair, what this bill would do is it would repeal a section of the code, 63.2-1709.3, that provides statutory protection for a private child placing agency that, I'm talking in the double negative. Let me phrase this not in the double negative. This section provides that no private child placing agency would be required to perform, assist, counsel, recommend, consent to, refer, or participate in any placement that violates their written, religious, or moral